I'm Mike Hackard with Hackard Law. Estate planning is about preparing for the moments we don't expect. In my years of helping families navigate loss, incapacity, and inheritance issues, I've seen how quickly life can change and how a well-prepared estate plan can make those changes easier to bear. One of the most important yet often underestimated tools in this planning is the beneficiary designation. Many people believe their will is the final word in estate distribution. Wills are essential, but they don't control everything. Some of your largest assets, life insurance policies, retirement accounts, annuities, and payable on death bank accounts, transfer through beneficiary forms, not through your will. Understanding how these designations work and how to manage them properly is one of the most effective ways to protect your family from uncertainty. A beneficiary designation is a legally binding instruction you provide to a financial institution. When you pass away, the institution follows that instruction directly, bypassing probate entirely. Assets with beneficiary designations tend to transfer faster, more privately, and with far greater certainty than those funneled through the court system. This brings significant advantages. Probate can take months, sometimes longer. It becomes part of the public record. It can create delays at the very moment your family needs stability. Beneficiary designations, on the other hand, can transfer funds within weeks. They stay private, they follow clear instructions, and they provide immediate financial support in times that can be emotionally and financially difficult. But these benefits come with responsibility. Beneficiary designations must be managed intentionally. When they're neglected, outdated, or inconsistent with your estate plan, they can lead to results you never intended. One of the most common mistakes is failing to update designations after major life events. Divorce, marriage, birth, adoption, and the loss of a loved one all change who you want to receive your assets. Yet, many people never return to update their forms. I've seen situations where an ex-spouse remained the named beneficiary simply because the paperwork was never revisited. Even if your will says otherwise, the institution must follow the designation. The form carries the legal authority. Another mistake is leaving beneficiary forms blank. Families sometimes assume their will covers the account. It doesn't. If no beneficiary is named, the asset may funnel into probate, defeating the purpose of having the designation at all. This can delay distribution, expose the account to creditor claims, and create uncertainty for loved ones. Parents sometimes name minor children as beneficiaries without realizing the consequences. Minors cannot legally manage inheritances. Courts may need to appoint a guardian, adding cost, oversight, and delay. When the child reaches 18, the entire inheritance becomes theirs outright, which may not reflect your hopes for how the funds should be used. A more protective option is to create a trust and name that trust as the beneficiary. A trust allows you to decide how, when, and for what purpose funds are distributed. Ignoring contingent beneficiaries is another issue. If a primary beneficiary passes away first and no contingent is named, the account may again flow into probate. Contingents provide a valuable safety net, ensuring the asset still transfers quickly and privately if circumstances change. One of the most significant challenges comes from inconsistencies between beneficiary forms and other estate documents. Families often update a will but forget to update their designations. When the two conflict, the designation prevails. This can leave heirs confused, disappointed, or even in conflict, especially when the designation is significantly outdated. Coordinating all documents is essential to avoiding these issues. The most successful estate plans integrate wills, trusts, and beneficiary designations so they work together. A will handles assets not governed by designations. Trust provides structure for minors, blended families, or beneficiaries with special needs. Beneficiary forms allow key assets to transfer quickly and privately. When these elements align, they protect families from avoidable complications during difficult times. I've seen how preparation makes the difference. One family never updated a retirement plan designation after a divorce. Decades later, the ex-spouse received the entire account. Another family named only a primary beneficiary on an IRA. When the primary passed away first, the account moved into probate, delaying distribution for nearly a year. And then there are families who coordinate everything, the designations, the will, and the trust. When the unexpected occurs, the process is smooth, clear, and consistent with their values. Estate lawyers help families accomplish this coordination. We review beneficiary forms, identify inconsistencies, recommend trusts where appropriate, ensure contingent beneficiaries are in place, and consider tax implications. Our role isn't to replace the forms, but to make sure they serve your purpose. Beneficiary designations are more than administrative paperwork. They are vital safeguards. They determine how major assets transfer, how smoothly your loved ones move through a difficult time, and whether your intentions are honored when you're no longer here to explain them. Preparing for the unexpected begins with reviewing these designations regularly, every few years, and especially after major life events. When kept current and coordinated with your broader plan, they provide clarity, protection, and stability when it matters most. I'm Mike Hackard. Thanks for watching.